One, is there any case law that comes to my mind that would help? And secondly, what are the career prospects?
So far as the case law is concerned, jurisprudence will give you so many case laws. For instance, when we talk about the Austinian conception of what is law, the black letter law, our Supreme Court in the case of AK Gopalan, it has taken a black letter interpretation, but when it comes to Maneka Gandhi's case, the Supreme Court, following the due process of law in the American Constitution, has of course breathed life into the dead words of the statute by saying that law is not only the black letter rule, but it should be reasonable, it should be fair, and it should be of course having a sense of justice. But that is what this jurisprudence is all about, wherein it is talking you towards the path of justice-oriented society, not only the law which is in the statute in the form of a black and white expression. And so far as, because there are so many case laws, for instance, when we talk about the historical school of jurisprudence, it will make you understand what are your customs, what are your traditions. And so, when the modern document like the Constitution, which has given you equality and liberty, and then see now there is a particular conflict going on between the traditional understanding of what is law and the modern understanding. So jurisprudence provides you enough cases wherein you can appreciate both the merits and the demerits of the traditional and the modern understanding of what should be the law. And so there are so many cases, and the sociological school is replete with so many cases wherein of course you understand the interrelationship between law and society and the social dynamics and social engineering, which of course form the very basis for development of society, because we understand law has not only got law only has a reformative role, law has of course a very important role to play in the society, wherein it can change the customs of the people, it can change the mindset of the people, and it can of course ensure that the society becomes more developed through, because law engineers changes in society. And these of course are the sociology of law and the law of sociology, which of course are the basic point, because they are truly, in my opinion, the sociology of law, the law of sociology, they led to so many developments in India and perhaps in the entire world, which we have witnessed. And that of course is so many case laws are there, so I cannot count them. So every particular case is pregnant with jurisprudential background. It has got instructions from the jurisprudential background. It has got theoretical foundations in the jurisprudential background.
That's quite fascinating, Professor. Starting with AK Gopalan and Maneka Gandhi, you went on to involve and point out to different decisions. And my last question to you is that apart from teaching the students of jurisprudence, where can they find employment? Where would it be useful?
So far as this employability aspect is concerned, definitely I would say that teachers who are good in jurisprudence, they can of course go for judicial services, particularly higher judicial services, wherein they have to interpret the moral document, the political document, the ethical document, which is known as the Constitution, which requires a very good insight into the understanding of the basic subject, basic principles of jurisprudence. And they of course can get jobs in, because so far as this placement and employability is concerned, the students of jurisprudence would definitely have an edge over other students, though of course I cannot tell you. For example, human rights. When you talk about human rights, what are human rights? Human rights are basically moral rights. So the students of jurisprudence would be very much welcome in those universities which have human rights courses as teachers, as professors. And then of course when it's a human rights litigation, the students of jurisprudence would be the most appropriate persons there to sort out this type of issues, which of course are having moral and ethical dimensions. So I would say that this particular subject, jurisprudence, which is projected to be an academic, which is not of course useful to you in the practical way of life, no, definitely I would not accept that view. I would say that this is the most practical subject. In fact, in my classrooms I say that this is not only a subject, it is the mother of all subjects.
I'm tempted to provoke you that not merely the matters relating to human rights, don't you think that jurisprudence in its own manner would apply even for litigation between Ratan Tata and Cyrus Mistry?
Yes, definitely. Why not? Because I told you in the beginning itself, this type of issues between Ratan Tata and then Mistry and then so many other, because when I was teaching trademarks law, and when I was deeper into the trademarks law, a jurisprudential background, for example, what is this common law? What is this common law jurisdiction? For example, when we talk about that Mercedes-Benz case, now ultimately our Delhi High Court, it has given judgment with a jurisprudential background. Now that is very essential. For example, when you distinguish between what is an infringement and a passing of claim, it is the jurisprudential parameter that will make you understand. For example, when you enter into intellectual property, what exactly is the jurisprudential background of intellectual property, that would of course help the court in arriving at the proper judgment. And the advocate can also advance holistic judgment before the court only when he understands what is the jurisprudential background. For example, the dispute between Pepsi Cola and then that other Coca-Cola, that of course wherein the advocate who drafted that particular lease agreement, he was paid so handsomely, and that particular draft agreement was mostly based on ethical and moral foundations and the legal arguments which can be built on the edifice of ethical and moral foundation. So the legal arguments cannot be separated from the ethical and moral background. So the ethical and moral backgrounds and the cultural and the social environment, that provides the fundamental basis for the legal arguments. So legal arguments are the superstructure, and these are the basic structures. So any advocate will find it very useful to construct his arguments in a very positive and a very constructive manner with the help of this particular background.
Thank you very much, Professor Murali, and the passion and the clarity with which you explain the subject, I am sure that the students would find it very helpful, and it would pave the way for many good teachers to come up in this sphere of jurisprudence.
Thank you so much.
Thank you. Thank you.